So the case of Leonard versus PepsiCo begins in the year 1995 when the Pepsi Corporation decides to announce a new advertisement campaign called Pepsi Points. And the idea of this campaign is that people who purchased Pepsi products would be able to redeem Pepsi points from those products and use those Pepsi points to purchase various types of Pepsi paraphernalia from a catalog. And in order to announce this campaign, Pepsi ended up producing a commercial which became the subject of a lawsuit. Now, one individual named John Leonard saw this Pepsi commercial advertising Pepsi points and all of the cool things that you could redeem with your Pepsi points, and desired to redeem one of the items that was featured in the commercial, which Pepsi refused to provide him, and so John Leonard sued. And I am going to show you this commercial that Pepsi released and see if you can spot the item that poor John Leonard wanted to redeem but was unable to.
Introducing the new Pepsi Stuff Catalog. Now, the more Pepsi you drink, the more great stuff you're going to get.
Sure beats the bus.
And so you may have been able to guess that John Leonard desired to redeem the Harrier jet, which was featured at the end of the commercial, for 7 million Pepsi points. And interestingly enough, in order to collect 7 million Pepsi points, a person would have to drink roughly 190 cans of Pepsi a day for the next 100 years. However, John Leonard found a loophole in the Pepsi Point catalog that said that Pepsi would allow people to purchase one Pepsi Point at a rate of 10 cents as long as they had 15 Pepsi points to begin with. So if they wanted to redeem an item that was, say, worth 100 Pepsi points, as long as they sent in 15 Pepsi points, they could purchase the rest for 10 cents per Pepsi point. And so John Leonard got together a check for $700,000 plus 15 Pepsi points. And he sent that in to the Pepsi company headquarters and asked them to please send him a Harrier jet. Pepsi, not surprisingly, declined to send a Harrier jet and explained that their commercial was a joke that was not to be taken seriously. And when he received that letter, John Leonard promptly sued. And so the issue before the court was whether the Pepsi Harrier jet commercial was a contract offer. And the holding of the court was no. And the court offered several reasons why the Harrier jet commercial was not a contract offer. So the first rationale that they give is that, as a general rule, advertisements are not offers. And the idea with this, which you may have recalled, was one of the arguments that was raised by the Carbolic Smokeball Company in the Carbolic Smokeball case, was that if advertisements that are posted to the general public are interpreted as contract offers, it sort of puts the company in a situation where they are facing unlimited liability. And as a general rule, when a store advertises say like a coat or some other item for like $10, we don't generally want to put the company in a position of having to be liable to provide a coat for $10 to every person that happens to come into the store. That in general, when a company advertises that, it is just an invitation for a consumer to come into the store and make an offer. But as you will recall from the Carbolic Smokeball case, this is not a hard and fast rule, and there are times where advertisements can be construed as contract offers. And so the next item for the court is to distinguish the Carbolic Smokeball case. And what they end up doing is saying that, look, the Carbolic Smokeball case was a different situation because all of those contract terms were clearly set out in the newspaper advertisement that was done by the Carbolic Smokeball Company. And in this case, there are still many items left open to negotiation, and so it's not a complete contract offer and shouldn't be construed that way. So they distinguish the offer in Carbolic Smokeball Company as being a complete offer, and in this case, it was an incomplete offer, and it still left essential terms of the contract open. And the third and probably strongest rationale of the court was that the advertisement was a joke. And in this case, they distinguish the case of Lucy v. Zemmer by by essentially saying that on the face of this commercial, it was not meant to be taken seriously, unlike in the case of Lucy v. Zemmer, where Zemmer sort of intentionally led Mr. Lucy to believe that he was making a good faith contract offer, even though he later said it was a joke. But for this case, the court goes through various sort of comedic elements of the commercial and concludes that it was obviously done as a jest or joke. So Leonard v. PepsiCo is generally thought of as sort of a frivolous lawsuit, and I'm not necessarily going to challenge that assessment. But I do think that it's worthwhile to think about how exactly the Harrier Jet PepsiCo case is different from the Carbolic Smokeball case. So we have the Carbolic Smokeball case on the one hand and the Pepsi Harrier Jet case on the other hand. And what I think is important to keep in mind about these two cases is that the distinctions that the court makes in the Pepsi Harrier Jet case to show that this case was different than the Carbolic Smokeball case, frankly, are kind of artificial. And a lot of the arguments that were made in the carbolic smokeball case that ended up getting rejected now get upheld in the Pepsi Harrier Jet case. And it's also relevant to think about the fact that we've looked at a lot of cases where people have raised this sort of contract defense of, oh, I was just joking, and it hasn't been very successful in most of those cases. And so, what makes the Pepsi Harrier Jet case the exception? And the big thing that you should keep in mind is that these two cases were decided in different eras. And so, the carbolic smokeball case is decided in the late 1800s. And in that time, there's no real consumer protection. There is no Consumer Protection Act. At this time, there's no claims for false advertisement as such. And there are also no real consumer safety laws. And so when this case of the Carbolic Smokeball Company comes before the Court of the Queen's Bench, you have this rather seedy uh, company that's peddling what is essentially snake oil that's probably, that's not only ineffective, but probably harmful to people's health. And they're making these grandiose claims in an advertisement, and someone finally calls them out on it. And you can imagine that the judges of the court that heard this case were not shedding any tears for the Carbolic Smokeball Company because, as they saw it, this company had it coming. And this was just one company, probably of many, many companies that were peddling these types of products that had no evidence of any actual effectiveness and were just sort of fleecing people for money, and there was very little legal recourse. Now, contrast that with the Pepsi Harrier Jet case. This is not an issue of consumer protection. It's not an issue of consumer safety. There are now laws in place that are designed to protect consumers. So these issues are less pressing for the court in the Pepsi Harrier Jet case. But what is probably at the top of the judge's mind who decides this case is this idea of frivolous lawsuits. And, I think that it's debatable whether there is a problem with frivolous lawsuits, but there is certainly at least a perception that frivolous lawsuits are a real problem. And this Harrier Jet case occurs just 1 year after the infamous McDonald's hot coffee case. And so the McDonald's hot coffee case occurs in 1994, and then in 1995 you get the Pepsi Harrier Jet commercial, and subsequently in 1999 is when the court eventually makes the ruling in this case. So you have a very different time period with different sort of public policy goals in mind for these judges. And so that's one of the reasons why these cases end up having such different outcomes. It's not even necessarily because they are that distinguishable in their facts, but rather because the judges are ultimately a product of their time and they have very different concerns about the legal system. That being said, I think that it is worthwhile to imagine how the Pepsi Harrier Jet case may have come out differently had John Leonard or some other plaintiff been a child. And you could imagine perhaps a child seeing this Pepsi Harrier Jet commercial, saving his money, going out, getting all of these Pepsi products, only to be told by Pepsi that actually the Harrier Jet is not a product that can be purchased. And in that instance, should a company that has targeted advertisements to children be held to a reasonable child standard. And so, in Lucy v. Zemmer, you had, of course, Mr. Zemmer assuring the court that he was just joking when he made this contract offer to Mr. Lucy. And the court said, well, Mr. Lucy didn't know that you were making a joke, and so we're going to interpret your contract from his viewpoint. But why shouldn't the same thing be true for an advertisement that's targeted to a child? Should a court hold the advertiser to the promises that a child thought sincere, even if an adult wouldn't? In other words, what would happen with the Pepsi Harrier Jet case had the plaintiff been a child who reasonably believed that that Pepsi was making a sincere offer, even if an adult wouldn't?